right? There we go.
Okay.
So, yeah, the recording has started, so we can go ahead and I'll give you the floor.
Awesome. Thank you so much, Bradley. Hi, everyone. My name is Giovanni. My law practice includes nonprofit corporate law matters. It is truly a pleasure to be here with you all today to discuss the Florida Senate Bill 554 and the potential impacts this proposed legislation may have on nonprofit organizations throughout the state. The effective date is July 1st of this year, unless our governor vetoes the bill or reject it. I don't see a reason why that would take place, but you never know. So right now, these changes are still a maybe. But today I would like to go ahead and still discuss why these proposed changes matter. I hope to provide an introductory overview of the bill. Obviously, I can't sit here and teach a class on it, but a good overview is good because it's a lot of changes. And I will highlight some of its key provisions. But first, I want to give a brief overview of the chapter itself. Let's see here. All right, so Florida's Not-for-Profit Corporation Act is codified in Chapter 617. It was originally enacted in 1990 and has since then undergone periodic revisions here and there. But this bill 554 would substantially modernize this chapter rather than making only minor revisions. In the past, like I said, there've been minor revisions, but this here is a major overhaul of the chapter. One of the reasons Florida Senate Bill 554 is so important is because nonprofit organizations, as you all obviously in here know, because you probably have been working with nonprofits forever, or you're on a board of some sort. At this day and age, nonprofits are operating in a very different environment than they were even just 10 or 20 years ago, right? So now nonprofits operate with greater complexity. Many nonprofits today manage multi-million-dollar budgets. Nonprofits own property, like real property too, employs large staff. Nonprofits engage in complex fundraising activities. Nonprofits also maintain public influence, right? As we've seen in current media, where that's been a topic. And nonprofits operate across multiple states. So certain nonprofits operate across multiple states and even internationally. So because nonprofits now operate with so much greater complexity and visibility, lawmakers and regulators are placing increased attention on governance, accountability, and just general transparency and oversight, operational oversight, right? So this bill is important because it reflects that broader shift. So it is part of a larger movement towards just modernizing nonprofit governance laws here in our state that so that they better align with the realities of how organizations function today. So two main bodies or groups or entities, whatever you want to call them, that had major influence over these extensive revisions that we're going to be discussing today were primarily the Florida Bar's Business Law Section, Chapter 617 Task Force. So there's a whole task force in the Florida Bar that was created for the purposes of this revision. And then we have the American Bar Association's Nonprofit Organizations Committee. Really, it's the Model Nonprofit Corporation Act that also influenced these extensive revisions. So in terms of the task force, right? So Florida Chapter 617 Task Force was created because Florida's nonprofit corporation statute had not been significantly revised or reviews like this in more than 15 and almost 20 years. So the purpose of the task force was to study this chapter through and through with some great expert attorneys in our state and recommend reforms that would modernize Florida nonprofit law. Especially after Florida had already substantially updated its for-profit corporate statute, which is, I believe, is Chapter 607. So that was the task force's role. The ABA, which is the second major influence, their nonprofit organizations committee, which I am a member of, they helped develop this Model Nonprofit Corporation Act, the fourth edition. The Model Act is designed as a model statute for states. So they're not laws themselves, but they're models that states across our country can adopt or use when revising their nonprofit corporation laws. And that's what happened here. The task force relied on a lot of the provisions from this Model Act. So it's comprehensive, and gives really good insight into how to, provide guidance and laws for nonprofits. That's that. All right. Next, we are going to look at some of the actual changes under the bill. I actually have a link here. Let's see. I'm going to put the link in the chat. I think I can do that. If you all would like to open up your own screens and follow along, if it'll provide a link, the link here. Here's a link instead. Here you are. There's the link. Okay. If you all want to share along, so I'll be popping up the actual proposed bill on the screen, so you'll see for yourselves, or you can open up your own screen. I share the link with you so you can follow along on your own computers. So for the purposes of reviewing a bill, though, just so you know, the underlinings indicate the proposed new language to be implemented. And the strike-throughs you'll see in the text indicates proposed removal of language. So one of the major themes of the bill is the modernization of administrative and filing procedures. So we're going to first look at section 617.123, and the bill modernizes this section by clarifying delayed effective dates and filing timelines, including retroactive effectiveness for initial articles of incorporation. So this is very interesting. We haven't seen these guidelines before, and I'll show you the language in a second. I think this clarity is good because now initial filers will have a better gauge on how to better anticipate tax obligations, right? Because that's primarily the purpose of like having a different effective date than probably the date you file, right? Because there are obligations like taxes, other legal liabilities and contractual terms that go into effect upon your effective date of when your organization is created. And so this proposed language here gives more clarity on that. So let me pull that up. Page 40, I believe. Here, I'm gonna scoot this over so you can see. And I'm not going to read all these bills to you, obviously, but I want you to get a feel for what the language will look like. So that way it won't be your first time seeing it will not be after July 1st. So I guess that's the perks of attending this. Those of you who are here, you get to see it. I mean, you can go on the Florida Senate webpage and see it, but we get to discuss it together in real time. So yeah, page 40. So you see here, what's interesting. So like I said, all the strike-throughs are what's being removed from the current statute, and all the underlines is what's being proposed, language is being proposed to be implemented come July 1st. So as you can see here, this is a lot of changes in terms of effective date and time. So what the statute did was now you could have an effective time, right? That's underlined. That wasn't a thing before. It was a date. Now the statute allows for your effective date to include a time now. So I just want to give you an example of like what that would look like. So let's look at this subsection C here. It says, if the record filed, so whatever record you're filing, whatever it's your initial articles of incorporation if you're forming, if the record filed specifies a delayed effective date, so if you have an effective date that you want delayed past the date that you actually send these documents to our Department of State to file, but there's no effective time. You didn't indicate a time. The statute says that at 12:01 on either the earlier of the specified date that you specified, but didn't specify time, or the 90th day after the date the record is filed. So what this is indicating, the more specific you are now, the better. If not, the statute then rules and will indicate when your effective date is. And again, this is important because we're talking about tax obligations. We're talking about other contracts that may be in place, other maybe grants, because a lot of nonprofits, you know, at the initiation, maybe they have grants ready to go, right? They did the work before they formed legally or formally with our state, and so certain dates matter for things like that. Okay, so this is just a glimpse into that section. So section 124 is the next section we're going to be looking at. So this section, the bill significantly modernized this section by expanding correction procedures for file documents and introducing a formal withdrawal process for filings that have not yet been effective. So now, let's say you send in your filing documents, whatever they may be, and you don't want them to be effective until a certain date. Well, now, for whatever reason, you have the option now to withdraw that filing before it becomes effective. So let's look at that language. What page did I say it was on? 43. So let's scroll down. Again, you're not expected to remember this stuff, but I believe that the nonprofits who are familiar with the statute, because the statute governs your entire organization, it regulates you, to me make the better nonprofits and tend to be the nonprofits are in compliance. And so the fact that you're here and you're getting ahead of this change is massive. It's good because then you can start to have these conversations with your board members and at your meetings and start to, you know, to speak to your consultants about your concerns and things of that sort. All right, so I want to look at 5A on page 43 of the proposed bill. Again, a lot of proposed new language here. So we're looking at the withdrawal statement. Again, this is monumental for our sector to be able to do this. So in order for you to withdraw, like if you want to withdraw a filing, you have to send in a withdrawal statement with it. And literally this proposed bill that will be law if our governor does not veto, lays out exactly what must be included in this statement, right? It must be signed by each person who signed the filing being withdrawn. Identify the filing to be withdrawn. If not signed, all persons who signed the filing being withdrawn, state that the filing is withdrawn in accordance with the agreement. Like it goes on and on. These are things nonprofits need to be familiar with, right? In the event you want to file something, but for whatever reason you want to withdraw it, you know, you have procedures in place now to do that. And this bill proposes a greater evidentiary weight to state issued certificates issued by their Department of State. It gives prima facie evidence that those documents are in effect when it comes to courts, public offices, and official bodies. One area where I've seen some type of pushback, if anything at all, like after I formed a new entity and you know my clients take their certificates of incorporation or whatever to the bank, and some banks are so skeptical still, right, about certain even if you have your EIN and your documents. So this is basically saying, hey, you know, what the certificates issued by this department is prima facie evidence. That means like on its face that the courts, the public offices, and official bodies should recognize what this document says. And that's on page 45. Again, it's right here. And this is great. This is great for our sector, making it easier for us to do business in our communities, right? All certificates issued by the department pursuant to this chapter must be taken and received in all courts, public offices, and official bodies as prima facie evidence of the facts stated therein. So this is good for us, right? Yeah. All right, so I'm going to move on. And by the way, I didn't say I was going to stop for questions. I prefer to answer questions in the end, but if you do have a question, if you can just, Bradley, I don't know if you want to regulate that.
Yeah, so I apologize. I should have said that in the beginning. If anybody has any questions, please put it in the chat and I will share them in the end. Like we can, like you said, go through them at the end.
Okay, perfect. All right, and I know this is like dry information, y'all, but like I'm nerding out. This is so good. But like I said, I share the link with you if you want to spend your own time looking at this, and you should. It's good practice. If you're on boards for your nonprofit, you're a leader, an officer, or what have you, you should be very familiar with this statute. A lot of nonprofit board members are not, and now this whole overhaul and revamp of it, you're gonna have to get. If you're already familiar, you're gonna have to get refamiliar and refamiliarize yourselves with these topics. So I know it's dry, but it's really, it's imperative that you know the laws impacting your business. Okay, so the bill expressly allows nonprofits to admit members either for no consideration or for consideration determined by the board of directors, creating, thank you, Beatrice Nerd Power, creating greater flexibility in how organizations structure membership participation. Now, what does this all mean? For those of you who may not know, consideration is a contractual term used to mean a bargain for exchange, right? I'm giving you something for something, right? At the grocery store, it's money. Some people barter. Some people, when they have their weddings, they barter things, right? So it's whatever you're exchanging for something. And this is great because now the current statute, the statute that the way it is now is more limited and less explicit regarding how membership consideration is structured. Let me share that language with you all. All right, here it is here. Except as provided in the Articles of Incorporation or bylaws, right? So you still have some type of discretion whether or not you want to include your specific language. So the statute allows that for you to have discretion there. A corporation may admit members for no consideration or for such consideration as is determined by the board of directors. This consideration may take any form, and to me, that's the kicker, right? And it allows for, you can get creative with this, right? You can have different tiers of memberships. It says that consideration can be either promissory notes, intangible property, or past or future services, even past services, right? If you have someone who provided a past consultant service, I don't know, CPA or somebody, if your board allows it, if your bylaws and your governing documents allow it, that can be enough consideration to allow them to be a member of your organization, right? And again, like I was saying earlier, you can get creative with this. You can have different tiers of memberships. Like, okay, membership class A, you all have to, your consideration has to be money. Member class B, your consideration has to be services. And if you have to volunteer a certain amount of hours to be a member, whatever. To me, this provision gives us so much more flexibility in how we can organize our memberships within our organizations and really use the manpower that we have in a more flexible way. Okay. Let's see where I left off at. Another important change under this bill is that it clarifies the limitations of personal liability of members of nonprofit organizations, because historically, people were concerned sometimes that if they join a nonprofit organization, if they would be exposed to the debts and lawsuits or financial obligations of the nonprofit, like board members. Like if you're now if someone voted you in to be the new president or the new vice president and all that, people were concerned, well, does this nonprofit have debts? Like, am I going to be obligated to pay this stuff or personally liable to pay this? And this new language sets better protections against stuff like that. Under the bill, the general rule is that a member of a nonprofit corporation is not personally liable for the acts, debts, liabilities, or obligations of the corporation solely because they are a member. This aligns closely, this aligns Chapter 617 more closely with the modern corporate laws and the ABA model rule we talked about earlier. This is important for like nonprofits that are trade organizations, chambers of commerces, social clubs, and things like that. So let me see if I can look at that language. Let's look at that language together. Here it is here. Again, so many new good juicy language in here that they're adding into this proposed bill. But let's look at this. This is what I found very interesting right here. There. The articles of incorporation or bylaws may provide reasonable means such as termination and reinstatement of memberships to enforce the collection of dues, assessments, and fees. You can reinstate a member just to collect fees and dues from them. So that's great. Now we can do that now, right? But here's the part I really want to look at. A creditor of a corporation may not bring a proceeding to reach the liability of, if any, of a member of the corporation unless final judgment has been rendered in favor of the creditor against the corporation. So while, you know, a final judgment can give leeway, but a creditor just can't come after the members because the nonprofit itself owes money. And we can get into also how to mitigate that even, right? Depending on what it is, you could have insurance to cover anything personal, like that a board member or a covered person in your nonprofit will be personally liable for. Maybe if then that depends if they're operating in the capacity of their role, which organization, but then that's where your conflict of interest policies come in, or languages in your bylaws can come in to cover that. But this is the language here that really protects your members from being sued by creditors or somebody because the nonprofit itself is indebted. Okay. Was I? Okay, next, I wanted to discuss the transfer of membership interests. So what are membership interests? Membership interests, they're essentially the bundle of rights a person has as a member of a nonprofit organization or corporation. Those rights can include voting rights, rights to inspect the governing documents or meeting minutes or whatever it is, the right to attend meetings, the right to participate in certain events. I don't know what else. The right to receive notices. The list goes on. But as a member, and that's what comes with perks. Certain perks come with your rights as a member. If you're whatever consideration you gave, you exchange for those perks, right? So under the current chapter, membership interests are generally much more restrictive, and in many cases are not freely transferable unless specifically allowed in limited circumstances. This proposed bill changes that significantly, okay? This proposed bill creates broader authority for nonprofit corporations to allow transfer of member interests. However, here's a caveat: it's not embedded in the law by itself, like some of the provisions we just looked at. The articles of incorporation, your governing documents, bylaws, what have you, policies, has to permit that. But it's definitely an option now. And yeah, so you're here and you're aware of it now. So come July 1st, it's something that you all can start to implement within your organizations. All right, what about directors? And I forgot to mention, y'all, like I obviously can't sit here and go through the entire bill. So some of these changes that I'm discussing during this workshop, it's not because they're more important than anything else in that 200+ document we're looking at today. It's just that these are the things that commonly come up that I think my clientele would want to know straight up, right? But again, this is just a general overview. So I don't want it to be construed that just because I'm discussing these things and these are the only changes, or these are the most important changes. That's not the case. Okay. So one of the more important governing concepts introduced by this bill is the concept of the qualified director. This is a completely entire new concept. It did not exist before, or it didn't exist in our current chapter the way it is written now. This is another concept that is heavily influenced by the ABA's Model Nonprofit Corporation Act. And it represents like a modernized version of how conflicts of interest and independent decision makings are analyzed, right? So what is a qualified director? A qualified director is an independent director for the purposes of evaluating sensitive issues that come up or decisions that come up. And the way I looked at it, it doesn't appear that it just has to be one person all the time, because a qualified director for one issue may not be a qualified director for another. And we're going to look at the language to see what qualifies a qualified director, or what qualifies a person to be, or what qualifies a director to be a qualified director. We're going to look at that in a second. But this concept becomes especially important in situations involving obviously conflict of interest, transactions, decisions on indemnification, review of conduct, employment, pay, stuff like that. This is where you would want a qualified director on those types of subjects. So again, like I mentioned, the current chapter does not contain a sophisticated framework like this for evaluating director independence. So this area is introduced to provide, I guess, a more structured framework on how to address conflict of interest issues that come up. So let's look at the language. Let's say page 59. Here it is, qualified director. And it tells you who and who cannot be. Someone has a material interest, and it tells you the definition of that. A material relationship tells you the definition of that. So a qualified director is a director, so you have to be a director of the organization at the time action is to be taken under this section, and who does not have an interest in the outcome of the proceeding or has a material relationship with the person who has an interest in the outcome of the proceeding. And the proceeding is, like I said, whatever it is you want to address, or that needs to be addressed. If it's a conflict of interest policy, something came up, an issue with employment, an issue with pay, right? You can designate a qualified director to oversee that process or to make the decisions. I see we have a question. I guess we could wait till the end. I'll wait till the end. Let's see. Maybe I can answer now and see what it is.
Do you want me to tell you?
Yes, I'll just.
So Beatrice asks, is a qualified director similar to having an expert opinion?
Not quite. You know, in my legal mind, an expert opinion, an expert is an expert that has vast knowledge on a particular subject area. And usually you would need a expert opinion, especially if there's a lawsuit and there's an issue that it can't be determined based off of a he say, she say. So it comes into evidence. We want to, convince the court that what we're saying is what it is. And you have an expert come in to evaluate the situation. A lot of time your experts will evaluate documents, will take maybe statements, maybe sometimes, right? It's more of a stringent, and it's more of a intense process. And you probably wouldn't need an expert opinion on something like an employment dispute within an organization, right? Now, if it comes to the issue where something's very technical, I don't know, I'm thinking, because I used to work in do insurance law. Like if you're at a building, your building collapses and someone gets hurt, a volunteer gets hurt, and the opposing counsel says, hey, by the way, the walls were decaying because of some type of the wood used, it was out of compliance, whatever. You would then hire probably an expert to come in and evaluate that to determine, what type of wood was it? Why did it, was it the wood itself? Was it the structure? Like it's more intense, and it's more of a nuanced process. But a qualified director is a person that is a director already on your board, or should be, and they are not materially adverse to whatever issue you want to look at in that point in time, for any conflicts that may arise. I pray I answered that and I didn't confuse you more, Beatrice. Okay. Okay, perfect. Okay, so yeah, so the qualified director is a completely new concept. When there's a material conflict, thank you. Okay, I'm glad I answered that. When there's a material conflict that arises, they're already on your board and they're a director and they're not materially adverse to the issue at hand and they can make a decision. Like I said, based on what I read here when I was preparing for this presentation, it doesn't appear that the qualified director has to be the same person because it wouldn't make sense to, because maybe an issue might come up where the qualified director was qualified for the prior issue, but not a pressing issue that came up, a new issue. So just keep that in mind. If you have anybody here have any additional questions about this particular new provision that's being added in here, shoot me an email. I'd be glad to answer and look further into it. But yeah, this is a complete new concept that they carved out into this proposed bill. All right. So next we're going to discuss section 830. This establishes the fiduciary standards governing nonprofit directors. Under the bill, and the proposed bill, directors are expected to act in good faith, obviously, as you know, exercise reasonable care, and act in a manner they reasonably believe to be in the best interest of the corporation. One of the important features of this bill is that it expands and clarifies what directors are permitted to rely on when making decisions. So, let's see, it allows directors to rely on information such as like reports, statements, and data, like financial data. I know we live in an age of data where, I guess that's almost the hot commodity now. It's like the hottest commodity is data, so directors permitted in the statute cannot rely on certain types of data, financial data, and professional advice. That's not entirely new, but it's expansive now. Officers or employees reasonably believed to be reliable, right? Legal counsel, accountants, and things of that sort. This is important because nonprofit directors are often volunteers and, are not expected to personally possess the type of expertise. So it goes back to the expert opinion question. Directors are not, expected to be experts in an area of governance or finance, or if there's a conflict of interest issue or law. So the law then recognizes, because of that, directors must be able to rely on professionals and consultants and organizational leaders in carrying out their oversight responsibilities. I see I have here page 19, but honestly, y'all, I don't remember what it even says, but let's look at it together. It's my second time looking at it. Okay. Here it is. Look at maybe section 2. The members of the board of directors or a board committee, when becoming informed in connection with a decision making function or devoting attention to an oversight function, shall discharge their duties with the care that an ordinary prudent person would, right? It goes on and on. And again, all this good juicy language in here, you should become familiar with. Within the particular person's professional or expert competence, or as to which the particular person merits confidence, or a committee of the board. So this really lays out how to perform that fiduciary duty, right? And what you're expected to do in carrying that out. So you're expected to consult professionals. You're expected to use your own knowledge in the capacity that you're operating, right? So like if I'm an attorney and I'm on the board, obviously depending on where I am, I'm not sitting as an attorney, but I have the expertise of an attorney in this capacity as a attorney who specializes in nonprofit law. I'm expected even then to operate within a reasonable means of that knowledge to be able to do my job and, and conducting my duties in the best interest of the corporation within my personal knowledge. Now, if my colleague who's also on the board with me, he or she is not a lawyer, maybe they're a CPA. And then so that person likewise would be expected to conduct their duties in the best interest of the corporation within their expertise. So this particular language here emphasizes that and really details in a sophisticated way what that looks like when you're making decisions as a director or officer in your capacity for your nonprofit. Okay. All right, so that's that slide. I'm going to move on to the next slide. So these next changes are discussing more the impacts of the courts, like how the courts may impact our sector now. And they're very, very important changes. So we're first going to discuss derivative proceedings. Let's just say proceedings. I'm sorry about that typo. Sorry. We're first going to look at derivative proceedings. So derivative proceedings are lawsuits brought on behalf of the nonprofit corporation itself, rather than for an individual member's personal harm. So a member, director, or other authorized person that alleges that the organization has been harmed. Usually it's harmed maybe by a director, an officer, insider, or somebody exercising control over the nonprofit. The claim belongs to the corporation, but the corporation itself is either unwilling or unable to pursue the claim. So another party steps in and sues on the organization's behalf or on the nonprofit's behalf. So let me see if I could put it in simpler. A simpler way to explain it is this, that a derivative proceeding allows someone connected to the nonprofit to step into the shoes of the corporation itself, right? And pursue claims when the individuals who are supposed to have failed to do so. So historically, Chapter 617 did not contain a highly developed or modern derivative proceeding framework compared to the modern corporate statutes. So currently, Section 617, 7404 allows members derivative actions, but this bill would repeal that section. So this bill repeals the current derivative action, which is Section 741, and creates sections 741 it creates Section 741 through Section 747. So it really expanded the topics on derivative proceedings. So let's look at that together. So here it is. So it tells you exactly who can bring these types of actions. And I'm just going to read some of it. Who has standing, right? So this means who can bring this action. A director, an officer, or a member may not commence a proceeding in the right of a domestic or foreign corporation unless such director, officer, or member holds that position at the time the action is commenced. So someone just off the streets, right, can't just, like a volunteer who's not a member, who doesn't hold a position, can't bring this suit. You have to actually be a director, officer, or member that holds position at the time the action is commenced. And was a director, an officer, or member when the conduct giving rise to the action occurred. So you have to meet both of these, and all these other provisions you have to meet to be able to bring this lawsuit, this derivative proceeding is the proper term, on behalf of the corporation. So this is my personal opinion. I think that what this does is creates it to me, it gets rid of the gridlocking a lot of times that I see, where members or someone who's not sitting at the top is powerless to enforce or get those who are at the top to do the right thing, right? It divvies out the power amongst members or someone holding a position at the time too, to protect the interests of the corporation. So whereas board members obviously have a fiduciary duty to protect the interests of the corporation or the nonprofit, now members can do something about it too. And like I said, it's not that it wasn't there before, but it really expands this framework and lays out it lays out the terms and under which conditions someone can do so, and it's very clear here. And it also talks about the dismissals, and it goes further and further. Again, all this underlying language is all new language. I know it can be overwhelming because it is. It is because it's so much new information, and it's imperative. It's like this is like 2 pages of like new language into the statute that come July 1st, nonprofits will be expected to adhere to them, like or be aware of them at the very least. It goes into discontinuance or settlement, proceeds and expenses and on termination of the action or the proceeding, and it goes on and on and on. So, yep, it keeps going. All right. So that's that on derivative proceedings. So next, I want to discuss court dissolutions. I'm sorry, I'm getting ahead of myself. Court removal of directors. So Section 617, 8091 is another completely new procedure. It was not in the, it's not in the current Chapter 617 that we have now. So this is another brand new concept that this bill proposes. It's a new procedure for the removal of directors by our courts or a judicial system. It's important because it gives nonprofits a judicial remedy when a director's conduct rises to a serious level, like maybe fraud or any intentional harm or gross abuse. Again, this goes back to what I said a few minutes ago, where I feel like this new statute is really not taking away power from the board of directors, but it's another way to keep them accountable. Because I know I've had my clients say, hey, I want to include language in my bylaw somewhere, especially if they're a founder, that I can never be voted out. I can never be voted out of or be removed, as from the board or whatever. But now this new section here, someone, maybe a member of your nonprofit or the director, raises this proceeding against you, the court will remove you. So rather than leaving the organization trapped with a harmful director, this proposed statute now allows a court to step in, remove the director, and even prevent that individual from returning to the board for a period of time. So again, a bunch of like this and the other provisions we saw is like a bunch of accountability here, right? This is a major governance accountability provision. This action may be brought only by like a member officer, like I said, someone closely affiliated with the nonprofit, that's a member officer director. And if brought by members, right, the complaint must be filed by members holding at least 10% of the corporation's voting power. So another major overhaul here for this, for our chapter 617. The court may also bar that director from being reelected or reappointed or redesignated for a period set by the court. So it's no more, like the board will decide, the members will decide. No, the court will. Of course, you go to court and you present your argument, you present your position. Of course, the court's going to take into consideration what you present, of course, but ultimately the decision is by the court or the judge. So we have 10 more minutes. I want to look at the language, but we only have 10 more minutes. And I know we started a bit later, so I want to be respectful of everyone's time. I'm going to look at that language quickly, but I'll make it quick. 5. Where is it? Here it is. Removal of directors by judicial proceedings. So you find it here on starting on page 115, and it goes down here. Right, I'm just going to randomly pick up a provision to read. The director engaged in fraudulent conduct with respect to the corporation or its members, grossly abused the position of directors, or intentionally inflicted harm on the corporate, and considering the director's course of conduct and the inadequacy of other available remedies, removal is in the best interest of the corporation. So obviously the court will look at, other available remedies, but when removal is in the best interest of the corporation, the court will remove you, essentially. That's tough, I mean, it's not something that a lot of board members might not like, but it's needed. Accountability is important. As we know, nonprofits don't belong to a certain individual. It belongs, well, I say nonprofit organizations belong to the public at large. And so a public court will remove you if needed. So that's that. All right. Next slide. Some other provisions to keep in mind that I didn't really do any deep research into, but they're also very important. Again, nothing's least important than the other in my slides. Even if I gave more attention to one than the other, or if I don't take into consideration the order of which I present this information, all of it's equally important, okay? I just thought I should put that disclaimer in this recording. But other changes to note, record keeping and inspection rights. So I believe it's section 1601. That's what my notes say here. So this section, this proposed language, would significantly expand and modernize the record keeping requirements for our sector, for our nonprofits. Under the proposed amendment, nonprofits will be required to maintain core governance and organizational records. So before, the records weren't really expanded like this. So that includes articles of incorporation, bylaws, member meeting minutes, and member actions from the prior 3 years. So you have to keep documents from the prior 3 years in your records at all times. Board meeting minutes, records of board action taken without a meeting, committee actions taken on behalf of the board, member communications from the prior 3 years, current list of directors, and most annual reports all needs to be kept from the prior 3 years. So that's huge. This amendment is important because it reinforces, in my opinion, again, stronger governance and accountability. So we're seeing here in our sector, we'll cover that in a few slides. It's all about accountability now and transparency. And that's what it just seems like we're moving in that direction on the state level and the federal level. So all of these point to accountability. So in practice, these records are often critical during audits, litigation, internal disputes, and things of that sort, grant reviews especially, and governance transitions, but our sector has not been doing a great job as a collective keeping up with our records. So in my opinion, I feel like this was probably our state's attempt to formalize the process to make sure then that we are held accountable as a group. So this section encourages nonprofits to maintain more sophisticated and organized corporate records consistent with modern governance expectations. In terms of member inspections, there'll be a provision added to shorten the notice period from 10 days to now 5 days. So right now, if a member or whoever in your organization, a member wants to inspect your records, under the current statute, the way the language is written, is a required notice of 10 days. This proposed bill, this SB 554, will decrease that notice from 10 days to 5, so in half. So it will permit reasonable inspections of the documents for if a member requests it. So that's that. Just keep that in mind. In terms of foreign corporations, so the bill creates, so there's another section that's created. It's not in existence currently. So in Florida, if a foreign corporation is acting without authority under our chapter, the Foreign Corporations Organic Laws obviously will continue to govern, but the unregistered foreign nonprofit, if they're not registered, would be deemed to have appointed the Secretary of State as the agent for service of process in specified circumstances. Because right now, if a foreign corporation is operating in the state of Florida, right now you would have to serve them. Excuse me, if a foreign corporation is operating in the state of Florida and they're not registered like they should be, right? That's a caveat. They're not registered in our state like they should be, and you want to serve them, you would have to serve them in their state, home state where they're registered. What this new bill is proposing now is saying, well, even if you're not registered, per this statute, the Secretary of State is now your agent to be served. So we don't have to go chase you around the country or wherever you're from to try to serve you. By way of you doing business here and you didn't register and you didn't have a registered agent, the Secretary of State is now your registered agent. So again, more accountability here for nonprofits. So then how do we get ready for this? I think everyone here who attended this is on the right path already. Bottom line is to prepare, right? And by you being here is huge. You're already preparing. You're getting the information. You're getting exposed to the actual raw language that's being proposed in the statutes. You're way ahead of the game already. So, the organizations that prepare early will be the strongest, will be in the strongest position to navigate these proposed changes coming July 1st. Again, I don't see why our governor would veto it. I mean, obviously, I'm not up there in Tallahassee unless some lobbyist comes down the pipeline somewhere and convinces him not to do it, but it's most likely happening. So begin reviewing and revising governing documents, policies, and internal procedures right away. Nonprofits should proactively evaluate their articles of incorporation, bylaws, in anticipation, right, of these changes I just discussed. Mind you, what I just discussed is only the tip of the iceberg. I know a lot of it was massive changes and completely new sections were being added in, but that's still this 1 hour I'm spending with you was only the tip of the iceberg of it all, right? So, we're expected to know the laws. Ignorance of the law is no excuse. So go back into your bylaws, look at the statute, once it becomes implemented, or look at some of the proposed bill now and start having discussions and holding strategic discussions with your boards and members. Engage your directors, engage your consultants, and your attorneys, your accounting people, your governance professionals, to start having conversations now on how you're going to move forward once this is implemented come July 1st. Quickly, this was brought up to me. I think Beatrice sent it to me. I did not see much details on specific dates right now. On April 23rd of this year, the U.S. Department of Treasury announced that the IRS, that now this is the federal level, plans to revise Form 990. As you know, Form 990 is how our sector, reports their financials. People like to call it tax return. It's not a tax return because most of my clients, 501c3s, we don't pay taxes. We're tax exempt. But people like to use the word tax return, whatever. But Form 990, it's IRS form, is going to be revised when we don't know. Unlike Florida, we have our prospective date for July 1st. For this change, we don't know. So right now, though, there are no immediate changes right now as far as we're concerned. But keep your eye out. I am going to share this article that I believe Beatrice shared it with me. So if y'all want to look at that too, to read up on it. Why is my thing keep doing that? Where is it? Here's the link, actually. To get ahead of the game. That's how you stay on top. You get ahead of the game, start looking into when the changes are coming and what kind of changes there are. Here in this case, we don't know when, but reading that article, you have a better idea of what to expect anyways. So yeah, on this particular issue, I advise that you consult with your CPAs. They may have a better understanding. I have a general understanding of 990s. but your CPAs are probably the best people to consult on this particular topic. Any questions? That's all I have. Right on time. I guess not. Gosh, am I that good? Like no questions? I broke it down good.
Yeah, and we'll be sending this out, and I'll send that article link out in the email that you just posted with the when we send it to send the recording out. But if anybody doesn't, if no one has any questions, one last time, anybody? Okay, well, I think Giovanni, do you have
Just a
anything?
lot of information to sit with, you know? So,
Yeah, again, it's only the tip of the iceberg. So
yeah.
I'm excited about it. I'm very excited. I'm like, I nerd out in this stuff. I'm looking forward to the changes.
All right. I'm happy for you. I'm texting my CPA right now.
Awesome.
All
All right, everybody. Have a good evening.
right. Bye-bye.
Bye, everyone.